Thank you for your interest in the history of special education laws in the United States. Special education is something that has only been recently added to federal and state laws in the last 50 years. The history of special education is both interesting and diverse. Special education came into the limelight primarily in the 1970s with the Education for All Handicapped Children Act. However, there were children with special needs long before this act became law. Prior to the 1970s, specifically in the early 1900s, children were determined to have disabilities based on their IQ test scores. Around the 1930s, if a student needed special education, there were only a few options for them. Once the teacher referred them for testing and the child was tested, they could either stay home, remain in a regular school, be put in an ungraded class, or be put into a state home, which was usually an institution. A child was automatically put into an ungraded class if they had been held back and were more than 3 grade levels behind. The 1950s and 60s brought some change for students with special education. During the 50s and 60s, the Civil Rights Movement provided opportunities for families of special education children to fight for their rights as well. The Brown versus Board of Education in 1954 was one case that would later help students with disabilities fight for their rights. In this case, the Supreme Court ruled that separating children in public schools on the basis of race was unconstitutional. It was deemed a violation of the 14th Amendment and did not provide the right to education to all students. During this time, students with disabilities were denied enrollment in public schools and were insufficiently served or sent to institutions. In 1971, the PARC versus Pennsylvania case used the Brown case to say that 14 disabled children had their rights violated by being denied access to the public school education. The court entered a consent agreement, and this agreement led to the framework for IDEA. In 1975, Congress passed the Education for All Handicapped Children Act, also known as EHA, to support states in protecting the rights of special education students as well as meeting their individual needs. This act was later changed to the Individuals with Disability Act in 1990. Up until the 1970s, children were excluded, including those who were deaf, blind, emotionally disturbed, or had intellectual disabilities. Children with these conditions were most often sent to institutions that had very poor conditions. The EHA guaranteed a free, appropriate public education to each child with a disability in every state and locally across the country. This is known today as FAPE. In 1986, a reauthorization of EHA addressed early intervention and mandated states to provide services to children from the time of birth. At this time, services started at the age of 3. In 1990, another reauthorization changed EHA to IDEA, and it added traumatic brain injury and autism as categories under this law. Congress also mandated, as part of the IEP process, that an individual transition plan, or ITP, must be developed to help students transition to post-secondary life. In 1997, another reauthorization of IDEA emphasized access to general curriculum. It also required parents to provide an opportunity to attempt to resolve disputes with schools and ELAs through mediation. In 2004, IDEA was aligned with the No Child Left Behind Act requirements, and in 2006, regulations required schools to use research-based interventions in special education. In 2008, they added more parental consent for continued services and education, as well as state monitoring, technical assistances, and enforcements, as well as allocated funds for special education. In both 2011 and 2013, regulations included clarifications to IDEA for infants and toddlers with disabilities. In 1978, the Family Education Rights and Privacy Act, known as FERPA, became federal law. FERPA protects the privacy of students' educational records. Until the students turn 18 or attend college, the parents control the rights to the student's records. Once the student turns 18 or attends college, all rights are turned over to the student. For students who attend private schools in California, the school district is responsible for identifying, locating, and assessing students with disabilities. School districts are not required to provide special educational services, as they are with public schools, but some students may receive services depending on the school district. One resource that I plan to use as a special education teacher to keep me up to date with current legal trends in special education is the Council for Exceptional Children. This organization helps to advocate for appropriate government policies and helps professionals obtain the resources they need to be effective in their careers. Another resource is the Special Ed Connection. This is an online resource that helps keep educators up to date on legal and educational policies. Finally, I'll be checking the California Department of Education website to stay current with my state's regulations and laws concerning special education. Thank you for watching, and I hope you gained some knowledge on the rights you and your child have in regards to special education.